Good day, and welcome to The Explainer. Look, today we're going to tackle a phrase you've probably heard a million times, but you might not fully get what's going on underneath. We're talking about being presumed innocent. Okay, so what does presumed innocent actually mean? Let's get right into it, because its real meaning, well, it's the absolute bedrock of a fair trial. And trust me, it's a fair bit more complex than you might think. This isn't just some fluffy, nice idea. It's a hard and fast rule of how our courts are supposed to work.
Right, so before we can really unpack the whole presumption of innocence thing, we've got to take a step back and figure out what a legal presumption even is. Yeah, it sounds a bit jargony, but stick with me, because it's the key to the whole shebang.
So here's the crucial bit. A presumption, it isn't actually evidence, not at all. It's more like a rule of the game. It's a starting point. It tells everyone in the courtroom who has to do the heavy lifting, who has the burden of proof. It's about setting the rules of engagement before anyone says a word.
And this slide here, this is a brilliant way to see it. You've got presumptions that are kicked off by a basic fact. You see a will that makes complete sense, so you presume the person who wrote it was sane. The rational will is the fact that triggers the presumption. But then you have the presumption of innocence. There's no starting fact there. An accused person is just there. It doesn't need a trigger. It's a fundamental rule that just is. It's the default setting.
Okay, so now that we've got a handle on what a presumption is, let's look at the big one, because this is where it gets really interesting. It's not just some words people say. It's a living, breathing instruction for everyone in the room.
Now have a look at this quote from the legal scholar Wigmore. He absolutely nails it. He says the presumption is a caution. It's basically telling the jury, hey, listen, you need to ignore everything except the actual evidence. No guesswork, no, oh, well, they must have done something to get arrested. You have to ignore the fact that the person is even in the dock. It's all about shutting out that noise.
So really, you can think of it as having two main jobs. Job number one is for the prosecution. You guys have to prove guilt beyond a reasonable doubt. That's your hill to climb. And job number two, that's for the jury. And it's a tough one. They have to mentally block out everything else. The arrest, the charges, the media circus, all of it. Their only job is to focus on the evidence presented in that room. That is it.
And this is a really fascinating bit of legal history. At one point, even the U.S. Supreme Court got this wrong. They called the presumption a piece of evidence for the accused. But that idea was, completely shot down. And for good reason, because the presumption isn't another thing you put on the scales of justice to weigh up. It is the scales. It's the whole framework. Calling it evidence just confuses the whole point.
Okay, so if we all agree this presumption is massively important, right? How does it get chipped away at in the real world, in an actual courtroom? Well, let's have a look at a few common traps that lawyers and even judges have to be really careful to avoid.
Right, check this out. Normally, when any witness gets up, a jury can think about, okay, what do they have to gain or lose here? It's a standard part of testing someone's credibility. But you can't do that in the same way for the accused. You can't tell a jury, well, be extra suspicious of what they say because they have the most to lose. That's a huge misdirection. It completely undermines the idea that they're innocent until proven guilty. You're basically starting from a position of suspicion, and you can't do that.
The why would they lie question. This one is a classic, and it's so dangerous.
It sounds reasonable, doesn't it? But look at the logic it sets up. A lawyer asks it, the jury thinks, yeah, I can't think of a reason, and suddenly they're assuming the person must be telling the truth. And just like that, poof, the burden of proof has secretly been reversed. Now the accused has to prove their innocence by proving the other person is a liar. That is a massive legal no-no.
And it's not just that one question either. The law is really on to a whole bunch of these little courtroom tactics. Grilling an accused because they can't prove why someone would lie about them. Or a prosecutor who says, well, there's no motive to lie, so they must be truthful. Even a judge asking a defense witness, so what's your theory on what happened? All of that stuff is out of bounds because it's trying to do the same thing, sneakily shift that burden of proof.
So, to stop all these traps from springing, the law has actually stepped in and put up some really clear guardrails. A fantastic example of this is right here in Victoria, with the Jury Directions Act. This is all about making the rules crystal clear so there's no confusion.
And this act is super specific. It literally spells out what a jury must not be told. See that first point? It directly outlaws that trap we just talked about. You cannot suggest the accused evidence is dodgy just because they have an interest in the outcome. And it also says judges generally can't start talking about a witness's motive to lie, unless the defense actually asks for it.
And it works the other way too. If the accused does decide to get up and give evidence, the law says the jury must be told a few key things.
They have to be told point blank that the accused didn't have to testify, and that them testifying doesn't change the prosecution's job one bit, that they have to assess the accused's evidence just like anyone else's, and again, that they can't give it less weight just because they have a stake in the outcome. It's all about hammering home that the burden of proof stays put. It never, ever moves.
All right, let's bring it all home. Why does all of this detail, this procedure, why does it matter so much? Because this isn't just lawyers arguing over fine print. This goes to the absolute heart of our justice system, and it's all about power and fairness.
To really see how special the presumption of innocence is, let's quickly look at something else, the presumption of sanity. In that case, everyone is assumed to be sane until the defense proves otherwise. See that? The burden is flipped. It's on the defense. This shows you that the way we handle innocence isn't an accident. It's a very deliberate choice to put all the pressure on the state.
So here it is, the big takeaway. The presumption of innocence is not a statement about reality. It's not the law being naive and saying every accused person is factually innocent. That's not the point. The point is it's a rule. It's a discipline. It's a shield that protects all of us from the massive power of the state. It's what forces the system to be fair.
And that leaves us with this final massive question, doesn't it? The law puts all these limits on what a jury can be told, all in the name of fairness. But does that make finding the truth harder? Or is a fair process the only way to even get close to the truth? That's the incredible challenge we put on the shoulders of 12 ordinary people every single day. Something to think about. Thanks for joining me on The Explainer.